sisters and brothers of Grenada, Carriacou, and Petite Martinique. Good evening to each and every one of you. I take this opportunity to salute our many visitors, friends, and citizens residing abroad who shared our recently concluded Carnival celebrations. Tonight, I wish to address you first and foremost on the Constitution Reform Project. Over the past few months, a government-appointed Constitution Reform Advisory Committee has been actively engaged in a process of consultations on constitution reform, which is expected to lead ultimately to a referendum on the Grenada Constitution. This committee is chaired by Dr. Francis Alexis, Queen's Counsel, a prominent and distinguished Grenadian constitutional scholar, and is comprised of 14 members representing various stakeholder groups and organizations in our country. The project scope and purpose, as set out in the project document, is, and I quote, to conduct public consultations on the Grenada Constitution with the citizens of Grenada, Carriacou, and Petite Martinique at home and in the diaspora. This will provide opportunities for citizens to contribute to the revision of the governing fundamental laws and rights. In addition, it will address major gaps and ambiguities identified by the 1985 and 2006 Constitution Review Commissions of Grenada and incorporate the advancement of fundamental human rights and standards. Subsequently, to present an amended constitution to citizens for judgment through a referendum. End of quote. Ladies and gentlemen, it is important to emphatically state at the outset that the National Democratic Congress supports the idea of constitution reform for Grenada. We have now celebrated 40 years of nationhood. By all measure, we are a young nation. Yet, sufficient time has elapsed and sufficient drama unfolded for us to take stock of how well our original Constitution has served us, what lessons we can take away from our historical experience to date, and how we might improve it for the benefit, protection, and pride of our citizens and future generations. Indeed, as earlier intimated, previous governments recognized this and established two Constitution Commissions, the 1985 and 2006 commissions, to attend to this need. The reports and recommendations of these commissions provide a rich source of learning and raw material for this committee in fulfilling its mandate. When the National Democratic Congress administration came into office in 2008, we decided that it would better advance the process if, rather than creating another commission, we recruit a constitutional expert to prepare a working draft constitution for public scrutiny and discussion based on the reports and recommendations of the previous commissions. We approached Professor Simeon McIntosh, former Dean of the Faculty of Law of the Cahill campus of the University of the West Indies, now deceased, who, at no fee to the government and people of Grenada, prepared a working draft along with explanatory notes which were widely circulated. The draft was discussed throughout Grenada, Carriacou, and Petite Martinique, and recommendations made to government. We supported this initiative by the present government for constitution reform and were pleased that Dr. Francis Alexis, Queen's Counsel, was asked to lead the effort. We attached such importance to this initiative that we offered our former political leader and former Prime Minister, Tillman Thomas, to sit as our party's representative on the committee. We did all of this in good faith, setting aside all narrow partisan interests in the firm expectation and belief that Dr. Alexis and his team would produce an output that would significantly and substantially advance the cause of constitutional reform in our country. On July 31st, 2014, as political leader of the NDC, I was presented with a copy of the report of the Grenada Constitution Reform Advisory Committee, which we understood was submitted to the Cabinet of Ministers on or about the 9th of July, 2014. It is our understanding that the Cabinet of Ministers have accepted the report and recommendations contained therein in their entirety, and that the committee is now charged with the responsibility to continue to advise the Cabinet in implementing its decision to hold a referendum on those recommendations early next year. Having carefully reviewed and considered the contents of the committee's report and its recommendations, we of the NDC feel constrained to state without equivocation that in our view, the proposed amendments to the Constitution leave unattended some of the most important and substantive issues that must be addressed in any constitutional reform. Instead, it focuses somewhat disproportionately on changes which, while proper, will not materially affect the operation of our constitutional democracy. Moreover, the process adopted and followed by the committee in reaching its conclusions and in making its recommendations to the Cabinet fell short of what can reasonably be expected. It is not clear from the report what operating principles guided the committee in its work. However, the NDC is strongly of the view that the proposed amendments to the Constitution leave unattended some of the most salient and substantive issues that must be addressed in any meaningful reform of the Grenada Constitution. In this regard, we feel compelled to make specific mention of the following 6 issues. First, the issue of term limits for the office of the Prime Minister. The Constitution Reform Commission of 2006 made the following recommendation in respect of term limits for the office of Prime Minister. That the Constitution be amended to provide that, and I quote, no person should hold the office of Prime Minister for more than 2 5-year consecutive terms, end of quote. The NDC takes the position that this is of fundamental importance to our democracy and should be put to the people in any referendum. Second, the powers of the Prime Minister with respect to the calling of general elections. The Constitution Commission of 2006 concluded and recommended that the Prime Minister should no longer be able to call snap elections, and that, and I quote, a specific date for holding general elections should be set by the Constitution. Again, the NDC takes the position that this issue is of fundamental importance to our democracy and should be put to the people in any referendum. Third, the issue of proportional representation in Parliament. This addresses the issue as to whether, in addition to the elected constituency representatives, each political party contesting the elections should be given the opportunity to send 1 or more representatives to the Parliament based on the percentage of the popular vote that party gets in the elections. Ladies and gentlemen, the rationale underpinning all proportional representation systems is to consciously reduce the disparity between a party's share of the national vote and its share of the parliamentary seats. If a major party wins 40% of the popular votes, but wins no seat in the general election for constituency representatives, it should nevertheless have representatives in Parliament so as to ensure that those 40% of the electorate who chose not to vote for the winning party still have a voice in the Parliament. In its report, the Constitution Commission of 2006 recommended that the Parliament should comprise of 4 categories of members, namely constituency representatives, proportional representation members, nominated members or senators, and a local government representative. In his draft constitution, Professor McIntosh also recommended the first 3 categories of members. Since we already have constituency representatives and senators in our constitutional arrangement, the crucial question here is whether the membership of the Parliament should be changed so as to introduce proportional representation. Once again, the NDC takes the position that this issue is of fundamental importance to our democracy and should be put to the people in any referendum. Fourth, the need for Grenada to have an opposition leader at all times. The Constitution Commission of 2006 suggested an increased role for the leader of the opposition and specifically recommended that some important functions should be performed by the opposition leader, such as sharing with the Prime Minister appointment of persons to key positions in the public service. Such an increased role can only be guaranteed if, constitutionally, the office of opposition leader is occupied at all times, regardless of the outcome of the general elections for constituency representatives. This will best be achieved if the Constitution provides for a proportional representation member to become the opposition leader if one party, regardless of which one, wins all of the seats in the general elections for constituency representatives. The NDC therefore takes the position that this issue is of fundamental importance to our democracy and should be put to the people in any referendum. Fifth, the issue of whether the chamber of our Parliament should be bicameral or unicameral. Simply put, this addresses the question whether our Parliament should be comprised of 2 separate chambers, one for the elected representatives, MPs, and the other for the nominated representatives, senators, or whether it should be comprised of a single chamber where both sets of members meet together to conduct the business of Parliament. While both systems have their advantages and disadvantages, it is generally accepted that the unicameral system is better suited to small nations and has the potential to significantly reduce the cost of conducting the business of Parliament to the government and to taxpayers. In its report, the 2006 Constitution Commission recommended that the Parliament should be comprised of a single unicameral chamber. The NDC takes the position that this issue is of fundamental importance to our democracy and again should be put to the people in any referendum. Finally, the election and tenure of the head of state. In its report, the Constitution Commission of 1985 recommended, after nationwide consultations, that whether there is a Governor General or a President as our head of state, that person should be chosen by an electoral college of all parliamentarians together with the chairpersons of the district boards and the Council for Carriacou and Petite Martinique. The NDC takes the position that this issue is of fundamental importance to our democracy and should be put to the people in any referendum. Ladies and gentlemen, the positions we have adopted on these issues are informed not only by the fact that they were all recommended after extensive public consultations to be put to a referendum by the previous Constitution Commissions of 1985 and 2006, but also because there are very sound reasons to believe that Grenada's constitutional democracy may be strengthened by such reforms. Moreover, there is nothing in the committee's report to indicate or suggest that public sentiments have changed on these issues and that they are no longer of fundamental concern to the populace. Sisters and brothers, constitutional issues are weighty issues. Time will not allow us to go into details and justifications for each of these issues in this address. With this in mind, we have developed a more detailed statement setting out in full the basis of our position. This statement is being published for the widest distribution and public scrutiny. Ladies and gentlemen, it is important to reiterate at this juncture that our desire and expectation to have these issues addressed in the Constitution reform process was made known at every available opportunity. We did so at the initial meeting held between our party leadership and the chairman of the committee at our offices. I, as political leader, did so at the launch of the project, and our representatives on the committee, Mr. Tillman Thomas, former Prime Minister, did so at the committee meetings and at public consultations held around the country. Moreover, calls for these issues to be addressed were repeated and reinforced by members of the public in the public consultations, some of which were televised. For us, it is important that we expressly and publicly acknowledge that some of the issues addressed in the committee's report are salient and substantial and were quite rightly recommended to the Cabinet as ones to be put to the people in a referendum. Without intending to be exhaustive here, these include Grenada's accession to the appellate jurisdiction of the Caribbean Court of Justice, the establishment of an Electoral and Boundaries Commission, the inclusion of the names of Carriacou and Petite Martinique in the name of the state, and the refinement of the fundamental rights provisions of the Constitution. We take the position, however, that if time, effort, and resources are going to be spent on the holding of a referendum on constitutional reform, then the proposed reforms must address the major gaps and ambiguities identified by the 1985 and 2006 Constitution Review Commissions. This is the stated purpose of the Constitution Reform Project. In particular, we are of the view that these 6 issues, not recommended to the Cabinet as ones to be put to the referendum, are so fundamental to the operation of our constitutional democracy that it would be a misallocation of time, effort, and resources to go to a referendum to alter the Constitution without addressing these issues. Sisters and brothers, I am sure you would agree with me that we definitely cannot afford the wanton waste of state resources at a time when resources are so scarce.